Okay, I think let's give it like 1 more minute and then we can get going. Okay, great. So I think let's get going. Thank you everyone for joining today's session and our webinar on STBB. And today our guest speaker is Stefan Hoogaard, and it's going to be on the ins and outs of insolvency law. So just a little bit about Stefan. So Stefan is one of our directors at STBB, and he is situated in the Claremont branch and deals primarily with litigation and dispute resolution and commercial transactions. So we're very honored to have Stefan here today. And before I hand over to Stefan, I just want to go through a few of the house rules. So if everyone can please keep themselves muted for the entire session. At the end, if we wanted to relay a bit of questions, we can unmute ourselves. That's the first thing. The second thing is we won't be sharing the presentation slides. If there are any notes that needs to be shared, we will be sharing them afterwards. So during the session, please feel free to share your comments, your questions, queries, anything in the chat, and we can attend to them. As we go along, we'll see how we can incorporate them in the presentation. If not, we'll be collating them and attending to all the questions at the end of today's session. But it's a very informative session, so we're hoping we get to all the questions. If that's not the case, then we can always reach out to the individuals to answer their questions. So for any administrative queries or feedback, you're more than welcome to email marketing1@stbb.co.za. And then the last thing is that we will be sharing the recording with all the participants after today's session. So without further ado, I will then be handing over to Stefan.
Thanks, Leonie. Let me just quickly get my screen sharing going. Okay, thank you. Yeah, thank you very much for that introduction, Leonie. Just a quick disclaimer, that photo that you guys have seen, it was taken before I started running actively again, and that can be seen in the cheeks. So yeah, I've been asked today to talk a bit about insolvency law, and it's a topic that I like. I practice in it fairly often. I've got a few matters currently running, dealing with insolvency law, and as the discussion will go and as will flow, you'll see that it can be quite a rabbit hole that you can go down. So I'm going to discuss today about the ins and outs of insolvency, but what I want to just start off with is just to say that I'm going to largely speak about the perspective of a creditor pursuing a debt owed by a debtor. I'm not necessarily going to speak that much about the debtor's perspective. And why I say that is, and as I'll illustrate later about the purpose of insolvency, is that it's a nifty tool that a creditor can use in certain circumstances. We'll get to that now. But of course, a debtor can also use that in specific circumstances. And why I'm saying that is that if you're running a company or if you're a natural person yourself, you can also take steps to declare yourself insolvent. I'm not necessarily going to discuss today that perspective from the debtor. That's, to be honest, that can even be an entire topic in itself. So just remember today when I talk, it's all about this perspective from a creditor. So with that introduction out the way, let's just start off by just covering the bit of the on the nose point. Insolvency and bankruptcy. What does that mean? That is a case where an entity, a company, or a natural person, we'll get to those distinctions a bit later, where the liabilities exceed their assets. The entity is insolvent. Now, that's the very basic point of departure, the rule of thumb when it comes to insolvency proceedings. But as you will see a bit later, there is more to it when it comes to taking steps of going down this route. So let's just all remember liabilities exceeding assets. I don't think there's any further explanation needed for that. So on this slide, what I've just tried to illustrate here, you will hear me speak about liquidation and sequestration throughout, and the appointment of a liquidator or trustee. Those are essentially interchangeable terms in the sense that you would liquidate a company or a closed corporation, so a juristic entity, whereas for natural persons of trust, you would sequestrate them. But ultimately, the effect or that line drawn in the sand, which we'll get to a bit later, is exactly the same thing. We just refer to different terms, liquidation or sequestration, depending on the debtor or the party whom you are trying to declare insolvent. So that's just what I've tried to illustrate there. What I've also just touched upon there is our specific legislation that is the source for insolvency. I've just listed it there. I'm not necessarily going to iterate it, but what I'll do is throughout the discussion, I will reference these specific acts and most importantly, the Insolvency Act. So let's just get right into it. And I think I want to spend some time on this slide because the question about what is the purpose really of insolvency, or rather, let me put it this way, why would a creditor want to declare a debtor insolvent? Why would a creditor want to go down this route, take this step or this course of action, as opposed to collecting a debt in the conventional way would be, or which would be obviously issuing a summons or even just applying for a money judgment. Now, there are various, how can I say, reasons that you would want to go down the insolvency route. And obviously, it's fact specific and depending on the merits. But the first most important point to take into account is that when a party is declared insolvent, there is a specific, let's call it a state or an event that occurs, and we call that the concursus creditorium. That is literally a line drawn in the sand. The moment that the entity or the person is declared insolvent, there's almost this freeze on that entity's estate, which means that the entity can't continue trading, or the natural person can't incur further debts, or at least there are certain repercussions if that happens. So the first point that I want to make, why insolvency is such a good tool from a creditor's perspective, is that you get this freeze position that occurs when a party is declared insolvent, which protects the creditors ultimately. As I say there, the purpose of insolvency is to wind up the estate of the insolvent for the benefit of the general body of creditors. You also see me refer to that later, where the liquidated trustee acts in the interest of the general body of creditors. That liquidator is appointed to wind up the estate for the benefit of the creditors. As again, keep on saying, as we will see later, but the liquidator can go and overturn dispositions. The liquidator can liquidate specific assets and distribute amongst the creditors. So the first point as to why insolvency, what the purpose would be, is that you've got that line drawn in the sand, which preserves the estate to the benefit of the creditors, and it avoids a deterioration of the estate, if you will, in the sense that it avoids money being squandered or assets being dissipated to the prejudice of creditors. Second point, as I said, I guess another primary basis would ultimately be for debt collection. It's not necessarily your primary purpose. And as I'll illustrate later when it comes to the ranking of creditors, you unfortunately, as a creditor, you're not always guaranteed that you're going to recoup 100% of your debt or even a cents in the rand. So although, of course, with insolvency, you have ultimately in mind that you're going to recoup your debt, I wouldn't necessarily peg that as a primary purpose. Again, as you'll see, the primary purpose is rather to get an objective party in there. And that's actually my next point. You want to get that concursus, and you want to get an objective third party, liquidator or trustee, that answers to the general body of creditors and the master of the High Court. I didn't say that there. You want to get that party in to take control of the insolvent estate, because that entity will then ultimately be able to preserve the estate, obviously within the bounds of law, and will be able to claw back payments made, dispositions made, claw back certain assets, and liquidate, with the idea that the creditors are ultimately paid. Granted, but as I said, your collecting your debt is not necessarily guaranteed. So yes, as I said, you want to get a liquidator appointed. And that just takes me to the next point. The liquidator has quite far-reaching powers, as we'll talk about some of them at a later stage beyond insolvency, and that's why it's quite important. So to contrast that with obtaining a judgment against the debtor. So obviously, as a creditor, if you go and sue, you go to trial or an application, you get a money judgment against the debtor, you will have to execute in the normal course. What that means is you have to have a writ issued and attach movable assets, possibly attach immovable assets, of course, if they have. What I'm trying to illustrate with the powers of liquidate is that obviously when the sheriff goes under cover of a writ, his powers are limited. He can only attach property if he finds the property. Whereas a liquidator has got far-reaching powers. You can hold financial inquiries. We'll get to that a bit later. You can summons witnesses to give evidence as to what transpired with certain transactions. You can follow the flow of funds because you've got access to all the bank accounts, the statements, you name it. So that's why insolvency is such a good tool, is because ultimately you'll get a third party appointed that has far-reaching powers and that can assist ultimately in preserving the estate. And again, as we said, the golden rule is that the liquidator will do that for the benefit of the general body of creditors. And then I mentioned corporate divorce there. I'm going to touch upon that a bit later in more detail. What I'm trying to illustrate there, and that's more in the case of entities where directors and shareholders are involved, more often than not, you get it that the directors and shareholders are deadlocked as to how to manage the company or as to how to deal with the assets, whatsoever the case may be, as to what the entity is what the purpose of the entity is. But then there's the stalemate, a deadlock. And that's quite important that insolvency, in this instance, again, you can do it as a creditor or even a director in the specific circumstances. Insolvency will give you this tool that it will essentially diffuse this deadlock and will result and give you the ability of a corporate divorce. Whereas a liquidator will come in and say to the directors, no more fighting, I'm here, I'm going to wind up the estate of the insolvent, liquidate their assets, and distribute them amongst the creditors. And of course, shareholders will also be seen as a creditor, although they will stand last in line. But ultimately, the shareholders will then be able to realize their equity. Whereas, again, in the scenario that I'm trying to describe, with a deadlock, that would not have been possible. So that is quite a mouthful on the purpose of insolvency. And I think this, to me, is always a good, how can I say, paves the way to the discussion of insolvency. I mean, now we're going to go into the nitty-gritties of the law, but it's quite important to know that as creditors, you've got this tool to your disposal. Obviously, assuming you can bring it into the specific requirements of the act, and then once you get to that point, once you get a court to rule on the insolvency and liquidate or sequestrate, depending on the circumstances, yeah, a lot can flow from that. So that's what I'm trying to illustrate there with the purpose of insolvency. If you guys have any questions, I'm going to try and get to that to the end, as Lehani said. So on that, I just want to quickly touch on the process of insolvency. So I'm not sure if we've got any Office fans here. You guys know Michael Scott, of course, the American version of The Office. I always think about what he did there in that scene where he said he declares bankruptcy, and then he said that, well, you can't just say so. And he said, well, I declared it. Now, and that's just a bit of an anecdotal meme there that I find quite funny, but that leads us into what the process is. Ultimately, it's not as easy as just declaring your insolvency. From a creditor's perspective and towards debtor, is that you need the court to step in. You need the court to rule on the insolvency. In essence, you grant a provisional liquidation order, sequestration, depending what it is, and then later you grant a final order. I don't think I'm going to go too much in the procedure of getting your liquidation order. I don't think that's necessarily important for today's discussion. And then you have a situation where a debtor can voluntarily surrender his estate, and you can also lodge liquidations with SIPC. As I said, I'm not really going to touch upon that today. I just want to illustrate to you that it is a formal process that has to be followed, because, of course, you have to reach certain requirements and show to the court and illustrate to the court why the estate should be wound up. Apologies, I don't think I clarified that that we also use the word wound up as interchangeable for a liquidation order or sequestration order. That means you wind up the estate, which is ultimately the liquidator's job, is to liquidate and distribute the assets and then wind up the estate for the benefit of the creditors. So just a quick slide here on business rescue, because I would imagine that some of you have in the back of your mind, but where does business rescue tie in with that? Must just say, big caveat, today is not a discussion about business rescue. That's a beast of its own. So what I put here in bold is that business rescue is a situation, or at least where a company is placed in business rescue and where business rescue practitioners appointed with the idea of rescuing the company, trading it out of a financially distressed situation. Is that the big differentiating factors between insolvency and business rescue is that you can only apply for business rescue where the company is in financial distress. So at the risk of not getting overly technical, it's not a stage where the company the company is insolvent just yet, but it's financially distressed. Now you're going to ask me how long is a piece of string. I do appreciate that. I don't think we have to go much into this topic. I just want to illustrate that it is an entirely different process that is. It's a process that you would go through long before the insolvency stage. And you'd also see a lot of creditors sometimes would take a company that's in business rescue and apply to court to convert it into a liquidated or insolvent entity. Again, the reason why you would do that is because you want to get a liquidator appointed. The business rescue practitioner in this instance would file a business rescue plan setting out his or her plan about how to rescue the company. Certain debts would be paid, obviously at a certain lower percentage, with the hope of ultimately trading out of the financially distressed state. So I just wanted to quickly, before we get into the nitties and gritties of the law, illustrate that there is this different process when it comes to companies. And then before we get into the specifics, one last point is that it's always important to note that for a creditor to proceed with an application for liquidation or sequestration, it must be based on a liquidated claim of not less than R1,000. I think it was £100 at a stage, but that's because, as you saw, the Insolvency Act was promulgated almost 100 years ago. So the debt must be liquidated. So, in other words, it can't be a damages claim. I mean, a good example would be an outstanding loan or an amount that's ascertainable. And that's just what we talk about, liquidated claim. And then obviously you've got a specific threshold, which actually is quite low if you think about the quite robust effect that insolvency has. So we're going to quickly talk about sequestration first. As you will recall from the previous slides, sequestration is the process of declaring insolvent a natural person's estate or that of a trust. We differentiate between the two versus liquidation, as you'll see now, because the requirements of sequestrating a person or a trust is higher. The threshold is quite higher. So I'm not necessarily going to read everything off of the slides. I think it's quite self-explanatory. Well, I guess, as I say now, I do see that I've written in shorthand, so maybe I'll just touch upon some of them. So this act of insolvency refers to a specific act committed by the debtor, which would entitle a creditor to go to court and say, well, I now need this person's estate declared insolvent and get a trustee appointed. So this is in addition to if you can prove actual insolvency, which, to be honest, more often than not, as a creditor, being an arm's length, you won't be able to do because you, of course, don't really have insight into that debtor's liabilities and assets. Obviously, in this instance, you'll know that you've got a liability owing to you as a creditor, and perhaps if you do a deeds office search, you'll know about immovable property, but you won't necessarily know about any other assets such as vehicles, or movable assets, shares, etc. And that's where an act of insolvency comes into play. Is that if the debtor commits such an act of insolvency, that's your first box that you tick to apply for a sequestration, with the idea of getting your sequestration order and appointing a trustee. And you'll see here that the theme that runs through is that the party must either indicate that he or she is unable to pay his or her debts. I think that's a bit on the nose point, or offer an arrangement or compromise. And what we're saying with there is not necessarily a without prejudice arrangement to pay a debt off where it's done without admitting the debt. I mean that a party can do, but where a debtor will say, well, I can't pay the debt, or a debtor will reach out to the creditor and say, gosh, can you please help me? Can I please pay 80% of the debt? That two very obvious acts of insolvency and would be grounds to apply for sequestration. But then if you look at the other requirements or other acts of insolvency, you'll see the theme that's running through there is that the debt is trying to evade paying debts, and that you'll see if they leave the country or if they dispose assets with the idea of evading payment of debt and prejudicing certain creditors. That would also be considered acts of insolvency. And then what I said there with judgment and null and return, what that means, you guys will remember what I illustrate or what I discussed with earlier, is that if a monetary judgment is obtained against the debtor and the sheriff has got a writ to go and attach movable assets, but the sheriff comes back and says, well, I couldn't find any assets, and the debtor hasn't pointed out any assets, nor does the debtor have immovable property, it will be seen as a null and return. That's what we call it. The judgment debt cannot be satisfied. In that instance, you can apply for sequestration on the basis that it's considered an act of insolvency. So when it comes to sequestration, the first box to tick is to prove an act of insolvency. That's generally, I must say, the easier requirement to prove. It gets a bit difficult with the second requirement, and this is the only required when it comes to sequestration of natural persons and trusts. As you'll see later, this is not a requirement when it comes to liquidating entities. You must prove benefits to creditors. And we'll get to now what that means. So this is quite a high threshold. And the reason why, I mean, the jurisprudence behind why there is such a high threshold is because ultimately sequestrating a person is an effect on that person's status. We're not necessarily going to get into detail today what that means, but ultimately you would imagine if you sequestrated, for the greater part, the debtor's hands are tied for quite a prolonged period of time as to what the debtor can do, incurring further debt, buying assets, etc., etc. So ultimately, the status of the debtor is affected, which is really a robust step and a robust order for a court to make. Hence the requirement of benefits creditors and why it is required to prove it. Now, what that means is, if we go on as how it has been quoted in case law, is that the creditor must prove that if the debtor's estate is liquid or sequestrated, there will be a non-negligible dividend for creditors payable ultimately with winding up the estate. What that means is that the creditors will get something out of the estate. And I'm going to keep it as vague as that because it's not necessarily a black and white requirement of, let's say, 50 cents in the rand or etc. But what must be illustrated is that essentially the debtor's estate is not being sequestrated for now. You need to be able to show that creditors will be paid something out of this process. Not necessarily 100% of what they claim, but at least something. And that's where we say not negligible. It mustn't be a negligible dividend. I guess I don't know how many different words I can use to describe that. But then that also takes us on to the second point. And I have used this requirement before. So as I said earlier, is that generally as creditors, you actually don't have much insight into the debtor's financial position. So how are you going to prove the benefit to creditors or rather non-negligible dividend? Chances are that you probably will not be able to, or it will be extremely difficult. But there is another requirement. And if you will recall what I've explained about the purpose of sequestration, if you can illustrate, obviously on the facts and your story that you'll explain in the application, if you can illustrate to the court that appointing a trustee to the insolvent estate will enable that trustee to go and find the assets, find money that's been dissipated, etc. If you can illustrate that, the court will see that as a benefit to creditors because obviously, as I said earlier, is that the trustee will have far-reaching powers. So if you tell the court, well, based on your facts in your scenario, you can clearly see that although the debtor has nothing on paper, you can see based on the story that you would explain to court that he's dissipated with assets. It's gone through this entity, this vehicle that he's fraudulently using. But we need to get a trustee in there with the far-reaching powers to go and recoup the funds for the benefit of creditors. The court will see that, or can potentially also see that as the requirement for benefit to creditors being met. I think that, yes, that brings us to the end of sequestration. Just to illustrate that you've got the two boxes to tick when it comes to sequestration, and that you've got quite a high hurdle to prove when it comes to sequestration and by proving as a benefit to creditors. And as I said, the reason why you do that is because of the effect it has on the party status. So that then brings us to liquidation of companies or closed corporations. I'm not necessarily going to refer to closed corporations. It's largely the same. For companies, you will find your origin Old Companies Act, the New Companies Act, and then of course for closed corporations, it's in the Closed Corporations Act, but it's largely similar. The basis for when you can apply to liquidate an entity. Now here, you will see the threshold is a lot lower in the sense that the most obvious is that you don't have to prove the benefit to creditors. So first point that I touched upon there is that the laws of insolvency will apply to the liquidation of companies. So although granted, not the requirement of benefit to creditors, you can also rely on acts of insolvency committed by companies if you want to apply for the liquidation. But what that point also illustrates is that the provisions of the Insolvency Act for post-insolvency, which we'll get to later, also applies for companies. So when it comes to insolvent companies, how to or the box that you ultimately have to tick is that you don't necessarily have to prove actual insolvency. Of course, if you can prove actual insolvency, you'll be able to obtain your liquidation order. But ultimately, you as a creditor need to prove that the company is unable to pay its debts as and when it arises. So that's what we call commercial insolvency. And how you will illustrate that is, it's dependent on the merits, dependent on the facts of the specific circumstances. To give you an idea, I applied for the liquidation of a company beginning last year where we started off with the liquidation application, then we settled, we got that made a court for order of court where certain payments had to be made. And when those payments had to be made, I think the attorney or the director kept on writing and said, oh, well, we need more time. We're just waiting for the SARS VAT refund to come in. And then a week later, they said they're now applying for bridging finance. And that's, I guess it's a bit of an on-the-nose example as to when the company is unable to pay their debts as and when they arise. In other words, they can't pay it. right there and then. That's considered commercial insolvency. And that's what you need to prove when it comes to insolvent companies to apply for the liquidation. If you don't have the benefit of proving if you don't have the benefit of proving commercial insolvency, again, as I said earlier, is that when it comes to arm's length, or you can call it hostile liquidations, even if you will, you generally don't really know the ins and outs of the debtor's financial position, or maybe you don't have the benefit of actually having a debtor that actually communicates to you. There is a provision where a company will be deemed commercially insolvent or deemed unable to pay its debts as and when it arises. It's simple. It's that when a written demand for the payment has been delivered to the company's registered address and they have not paid for a period of 3 weeks, that company will be deemed unable to pay as debts as and when they arise, or deemed to be commercially insolvent. And then a last heading or a box that you can tick when it comes to applying for liquidation is that if you can show to the court that it'll be just and equitable to liquidate the entity, you will be able to get your liquidation order. Now, that is another requirement where I can't give you, or let me put it there are no black and white examples. Same topic as saying earlier, is how long is a piece of string. You need to be able to illustrate to the court as creditor that winding up the company and getting a liquidator appointed will be just and equitable, and will be to the benefit of creditors, if we want to stick to that topic. And it is in the best interest for this company to be liquidated. And I've referenced deadlocks there, but other examples, if you can illustrate ultimately that the directors are acting recklessly and they are acting in a specific way where the assets of the company are diminished, you would want the court to step in, even on an urgent basis, to get that liquidation order and get that third party in, ultimately to act in the benefit of the creditors. Ultimately, you want to preserve the estate, draw that line in the sand for the benefit of the creditors. So that's where the just and equitable leg comes in. It's quite a wide discretionary powers afforded to the court in specific circumstances to be able to liquidate an insolvent company. So yes, so for insolvent companies, if you can prove that the company is unable to pay debts, or there's deemed commercial insolvency, or depending on the facts that it'll be just and equitable to liquidate the company, you will be able to get your order. I'm going to have to move a bit quicker because I've got a lot to get through. For solvent companies, it's a little bit different. I'm not going to spend too much time on that. Obviously, with solvent companies, as we illustrated earlier, is that they can pay their debts, but you can still apply to court to liquidate the solvent company. So, for instance, here is that if the company was actually if the company was actually placed in business. We just mute there, please. And if there's no prospects of rescuing the company, that's what I illustrated earlier, is that sometimes a company is placed in business rescue, but it becomes overtly apparent that this company is not going to be rescued. Then an interested party can apply to liquidate the company. Then also there's that just and equitable requirement or leg from creditors' perspective as well. As I illustrated, it's largely the same as I've just illustrated with insolvent companies. But here, and this is where the deadlock comes in as well, when it comes to directors' deadlocks and shareholders' deadlocks, and where that deadlock can result in injury to the company, or where the shareholders are ultimately prejudiced. In this instance, as I said way in the beginning, and this is again where it's a good motivation and tool for insolvencies, that where the directors have tried everything in their power to see eye to eye, and the shareholders, well, at least it doesn't have to be both, the company can be placed in liquidation. And again, as you can see, and as you can remember, the purpose behind it is because there's now a stage reached where this company is in a stalemate. It's not going forward. It's actually acting to the prejudice of the shareholders, and company must be liquidated so that objective third party, the liquidator or trustee, can be appointed with the view of ultimately winding up the estate. So that's what those are the boxes that can be ticked for solvent companies to apply for the company's liquidation. So as I illustrated earlier with the process, so what will happen with sequestration liquidation? You will first, as creditor, apply for a provisional liquidation sequestration order. That's your first day in court. From there on will flow certain requirements to serve and publish the order, and then you will come back to court to get a final order, which will then kick in the process of winding up the estate by the liquidator. So let's touch upon post-insolvency. Of course, as a creditor, you've taken the steps to get it to the insolvent stage where the court has declared insolvency, as I've just explained, provisional liquidate and final orders. And now the liquidator or trustee is appointed with the view of fulfilling his or her mandate, and that is to wind up the estate for the benefit of the creditors. That's the process that follows afterwards. And now I'll show to you where I said earlier is that this process afterwards and the powers that the party has is greatly why you would go to court to have a party liquidated or sequestrated. So as we said, it's for the benefit of creditors. So the creditors largely run the process in the sense that you've got meetings of creditors where they would vote on the appointment of liquidators. So depending, there are certain rules involved in this as to who you want appointed. Ultimately, as with anything, certain professional, I mean, you would prefer certain professionals appointed to do the job, etc. So that the creditors will have a say in the appointment of the ultimate trustee and liquidator. That will happen at the creditors' meetings, which is a meeting held either at the master's office or at the magistrate's courts, depending on the specific jurisdiction. And at these meetings, the creditors will vote in on the powers of the liquidator. So that will be powers of disposing of assets, of proceeding with litigation when it comes to outstanding debts and perhaps in a company that's been trading, etc. But it's important to note that the creditors vote in those powers by way of a resolution. So I say they note extension of powers. So with any administrative process that runs its course, having a first and second meeting of creditors convened generally takes some time. But in certain circumstances, depending on the nature of the matter, the merits of the case, and the entity that you've liquidated, there may be reasons or for the liquidator to have to act immediately. Maybe it's to carry on business, for instance, a farming enterprise or where there are perishables. In those instances, the liquidator can apply to court or the master to extend his or her powers to do specific things. I'm not necessarily going to go into that. I just want to illustrate to you what happens post insolvency. And that liquidator can then get an order to extend his or her powers with the idea of either preserving assets, selling assets, or continuing a business operation because it is immediately required. And then the most obvious requirement of for post insolvency is that there would be a liquidation and distribution of the estate. That's ultimately the primary job, mandate of the liquidator is to liquidate assets and distribute it amongst the creditors who have proven claims. And as I'll get to now with the next slide, we'll deal with a bit more in detail. The process of liquidating the estate also means recouping certain dispositions and dealing with specific dispositions that have been made. And I'll get to that in a second. So Of course, at the meeting of creditors, your creditors will prove their claims. So I think it's important to note that as a creditor of an estate, you are not obliged to prove your claim in the estate. But if you have not proven your claim in the estate, you will, of course, not share in possible dividends being paid. Now, creditors rank in the insolvency process. So it would be secured creditors. That would be, for instance, a creditor where the debt alone is secured by a mortgage bond, and they would rank highest. Preferred creditors would be employees and SARS, and then concurrent creditors. They are the creditors that don't necessarily have security for their debt, and they would stand last in line when it comes to payment of possible dividends, depending on the percentage of their claim, but depending on the free cash available once all the assets have been liquidated. And I see now I didn't put it in there. Behind them stand the shareholders. So when it comes to realizing their equity, so it's quite important to know the ranking of creditors. And then what I say at the bottom when it comes to a contribution of admin charges, and this is quite important when it comes to a concurrent creditor's um, decision as to whether to submit a claim to prove a claim, is that there may, in certain circumstances, be a risk that the concurrent creditor or petitioning creditor, I'll get to that now, will have to actually pay into the admin charges for winding up the estate. So, of course, anything that is winding up the estate requires specific charges, admin charges, the liquidator, giving a bond of security to the master, etc. I don't think we have to go down what admin charges entail, but what can happen is in certain circumstances, there won't necessarily be a surplus of cash available to pay the admin charges. And if that's the case, then a concurrent creditor can actually be asked to pay into the estate. And that's why when it comes to a concurrent creditor proving a claim in the estate, it's important to do your due diligence, or at least ask the liquidator, is there a risk of a contribution being payable? Now, fair enough. I think as I keep on saying is you don't necessarily have any insight, or not necessarily, in certain circumstances, you can have little insight as to the asset basis of the debtor. So you won't necessarily know whether a contribution will be payable. So the best step that you can take is to ask the liquidator whether there will be a risk. More often than not, they say yes, there will be a risk that a concurrent creditor will have to contribute to the admin charges. But it's important to note that there is that risk, especially if you're a concurrent creditor and you want to submit a claim. And it's also important to note, if you're a petitioning creditor, so a petitioning creditor is the creditor that actually brought the application to liquidate or sequestrate. If no further claims are proven, that petitioning creditor can be seen or can be asked to contribute to the admin charges. So that's quite an important point when it comes to decision whether to submit a claim. So this is now where it gets quite interesting as to what happens post insolvency. And I've only touched upon some of the more prominent how can I say, scenarios or aspects of the Insolvency Act for the purpose of today's discussion. And this is now, I think, when I discuss this, keep in mind that, again, when we talk about purpose of liquidating an entity, to get the liquidator appointed, because the liquidator will have certain powers. That's what we talk about now, is to claw back certain dispositions. We'll get to that now, but I guess unfortunately so, it's also to have it in the back of your mind as a creditor dealing with debtors now, is that, let's say you've accepted certain payments from a debtor, and you'll see now where the problem can come in, is that as a creditor, if you've received payments, there is still the risk in specific circumstances where the liquidator can come back to you and say, well, you now have to pay back that money and you now have to submit a claim in the insolvent estate. And that is I guess the flip side of the coin as to the purpose of the liquidation, in the sense that yes, the liquidation is there for the benefit of the general body of creditors. But if you're a creditor that's received payment, the court can actually, not the court, well, it is ultimately done by a court order, but at the instance of the liquidator, can overturn that payment and force you to put in a claim in the estate, because all of the creditors need to be in the same boat. You cannot necessarily be preferred above others. So the first point that I want list, I'm not going to spend too much about that, but it's a property of the spouse of the insolvent, that where the spouse's estate has not been sequestrated as well. So either the spouse's estate can independently be sequestrated, or if they're married in community property, it will automatically also be sequestrated. But what I'm trying to get at there I'm just saying the property of the spouse will also be attached by the liquidator. This is a step that follows the sequestration of a person. So the spouse's assets will also be attached, but it will be on that spouse's, or it will be on that spouse to apply for certain assets to be released if it cannot be said that those assets should fall within the insolvent estate. I'm not necessarily going to spend too much time on that. I don't think it's that important for now, but it's just something that has to be taken into account. So, voidable dispositions. So, in terms of Section 26 of the Insolvency Act, where the insolvent, so this is now again company or natural person trust, it doesn't really matter in this instance, where the insolvent made dispositions. So that's the first thing, a disposition without counter value, in circumstances where the insolvent at the time that the disposition was made was insolvent. I just realized that's the most convoluted way of describing this point. But what I'm trying to illustrate is that if the insolvent at a stage where it was insolvent had made a disposition and there was no value coming into the estate, that disposition can be overturned. So to give you a very clear example is that where a company has paid, let's say, paid rental on behalf of a third party to a creditor. So from the creditor's perspective, the rental has been paid. To be honest, in this day and age, like when you receive your money, you don't necessarily, it doesn't really matter from where the origin is, but can be accepted that there's no counter value for that rental being paid because the company's now paid it for a third party where the company did not get any benefit from that. The liquidator can then take steps to overturn that disposition. So ultimately, I think that's the most obvious example, is that if there was a disposition made without counter value, the court can overturn that disposition at the instance of the liquidator, and it can be clawed back to go into the estate of the insolvent. So the next one, Section 29 of the Insolvency Act, voidable preferences, and this is quite an interesting one. And this is where creditors, I think, to some extent, I guess to the extent possible, must be on their toes, in the sense that, again here, if a disposition was made by a debtor within a period of no more than 6 months from the date of liquidation, where that disposition was not made in the ordinary course of business and was made, of course, in insolvent circumstances, and where it was made with the idea of preferring creditors above another, the court can overturn it, of course, at the instance of the liquidator. And this is quite an important one, and a tool that liquidators often use, is that essentially, again, the overarching jurisprudence behind it all is that all of the creditors must be in the same boat and enjoy the same benefit of the estate, or at least, be in the same boat. In this instance, creditors cannot be seen to have been preferred above another. And if that is the case, that disposition made to that creditor can be overturned as well. And that it happens a lot. I've seen it happen many times. So that disposition will be overturned, and that creditor will ultimately have to put in a claim in the estate, as we just explained. sale of businesses, I think most of you would know this requirement. This is also quite important. Here it's a case, it's largely the same as with the dispositions, but here there is this added requirement of publishing the intended sale of the business, goodwill, or the property, if it's not done in the ordinary course of business. If that publication has not been made, it can be overturned should the company be declared insolvent. Just a few last aspects, the effect of lease agreements, and this is if the tenant is the insolvent. In this instance, the liquidator can have has a decision, an election to make whether the lease will carry on or not. More often than not, they would elect that the lease agreement comes to an end. Of course, the landlord will have a claim for outstanding rental or even damages claim for loss of rental, which will have to be put into as a claim, proved as a claim in the insolvency process, as I explained earlier. But what I wanted to point out there is that the landlord's hypothec the landlord still enjoys the preference of the hypothec in the sense that, and as you know, that there's a tacit hypothec over the tenant's assets as situated on the lease premises for payment of outstanding rental. So if the tenant's liquidated and the liquidator decides not to proceed with the lease agreement, the landlord can insist that the hypothec be acknowledged. You generally write up an inventory. The liquidator will say the hypothec's acknowledged, and those assets will be sold, and the landlord will enjoy preference from the proceeds for the claim proven. There is a threshold of 3 years outstanding rental immediately prior to liquidation, but that's not too important for today's discussion. The important point is just to know that the landlord's hypothec does not fall away. And then in closing, I think a burning topic for a lot of people would be, to what extent can directors of an insolvent company be held personally liable? This is, I guess, also a topic in itself. It's not impossible to hold them personally liable, but it is difficult. Okay, so let me illustrate in the sense that insolvency, declaring a company insolvent, or at least yourself, sorry, this only counts for companies winding up your own company. It's a recognized process. I mean, Donald Trump did it how many times? If you have ever heard his story, it's a recognized process in business that a party or directors can go down that route. And ordinarily, you cannot hold directors personally liable. We've got a corporate veil. There's a reason why you've got companies that are distinct from directors. But the biggest caveat is, of course, you don't want to have directors get off scot-free if they have acted grossly negligent or reckless, whilst knowing that the company is in an insolvent state. That's kind of the rule of thumb. There's a lot more to it, but in those circumstances, directors can be held personally liable for creditors' debts. And that actually also counts as a warning for directors that you need to be quite vigilant when running a company, in the sense that if you have a stage where it's clear that it's insolvent, or at least commercially insolvent, and if you carry on doing so, fair enough. I'm not saying that you cannot endeavor to trade yourself out of that position, but especially if you have creditors unknowingly going through this process of providing you stock, whatever the case is, you can be seen as being quite reckless in those circumstances. And as a director, you can be held personally liable. So yes, although difficult, it's not impossible for a creditor to hold directors personally liable. And then with 6-7 minutes to spare, as I said earlier, is that a natural person, the status is affected, and that natural person, obviously, like as I said, the hands are tied. Now, it's not forever, and again, this is also an entirely separate topic. But that natural person can and will have to, at specific stages or circumstances, apply for his or her rehabilitation. quick audit. So that's basically an occur for me, but it's important.
I think Stefan just has some technical difficulties. So maybe, Stefan, if you can hear me, just you can repeat the last bit and maybe just check your signal on your end. Sorry, everyone. It seems like he's dialed off just to and he'll probably just log in just now. And then, oh, there we go.
I
Stefan,
don't
we
know what
didn't
happened.
hear the last
There.
sentence. We didn't hear the
Um,
last sentence, but I think then maybe we can end off just with one or two questions. I think I currently only have 3 questions, and then we can end off today's session.
I can't even remember what the last sentence was. Um, I think I just said that as a insolvent natural person, you will have to rehabilitate yourself. Um, yeah. Any questions?
Okay, great. Yes. So we do have one from Mark, who's asked, would a liquidator pursue a business if there was not much left for the creditors, um, and the creditors could end up paying in for the liquidation?
Yeah, no. Very good question. So I think it's twofold in the sense that the liquidator ultimately answers to the creditors and to the master. So the liquidator obviously has to take a commercial judgment. They can't just go crazy and incurring legal costs and pursuing specific I don't know dispositions, etc. If the prospects of it are slim, but also it's important to note that the creditors can actually intervene in that and actually, how can I say, bar the liquidator from doing that specifically for that exact reason. So I hope that answers the question. It is this interplay between the liquidator, the master, and the creditors. That's quite important to note that. So although as a creditor it would be nifty to apply for the liquidation, you don't have to necessarily see this process through and incur millions of rands because again, it is a process used to your benefit, but ultimately you don't have to go the whole 9 yards.
Yeah, I think that also kind of answers Dale's question, where Dale's asked, would there be any instance in which it would be to the company's financial detriment to apply for the sequestration of a debtor, which I'm assuming is
Oh,
similar
yeah.
to the previous
So,
question,
yeah,
where
so
you don't have to go the whole 9 yards.
well, yeah, but I also tried to illustrate previously, especially when it comes to sequestration, is you need to really think it through before you pull that trigger because you need to understand why do I really want to do it? What will be the benefit? And then you've got the danger of a contribution. So there can be circumstances where, as a creditor, it can actually be not to your financial detriment. That's a bit of a dramatic one in the sense that it may cost you a little bit more to pursue this possibility of getting paid, and you're not even guaranteed to be paid. So, unfortunately, Dale, yes, that risk is always there, and it's always something to take into account before you take that step.
Yeah, I guess the due diligence is always your starting point with any application, or decision to be made on a company's part.
Yeah, and I think, sorry, just one more thing, and that goes what I've kept on saying is that although due diligence is important, it's almost difficult to actually act or how can I say to properly do that due diligence because more often than not you don't really have insight. That's why it is sometimes it's even a catch-22 as to whether you want to go down that process.
Okay, great. So then the question from Bashi, that was sent directly to me, if you can't see it in the chat, is more from the data side. So if a company is provisionally liquidated and the financial position of that company improves before the final order is made, the question then is, can the provisional order be dismissed on the return date?
Yes, it's just a simple answer. Yes, it can. So that's why you
Okay.
have a provision.
Yeah, basically the provision makes sense. Um, and then the last question that I have is from Trevor, and it is, how successful is a composition and how often is it utilized?
If I'm not I don't know if I'm being a bit daft, but I don't know if I 100% understand the question. You don't want to perhaps unmute yourself
Maybe,
and just ask.
yeah, I think also unmute yourself because I was so sorry. I thought maybe I missed something on the composition, but maybe I'm also not understanding the question. Um, so Trevor, if you're still on, if you can unmute yourself, let me just see if.
Yeah, Trevor's always welcome to phone me as well.
o-
Just on
Okay,
that,
great.
yeah, just before we wrap up on that second question, can directors of the company apply for business rescue when a liquidation process has been initiated? The short answer is yes. It gets a little bit technical in the sense that if a creditor has applied for liquidation, of course, more often than not, there's sometimes a counter application for business rescue. But once a final liquidation order is granted, then the die has been cast. Um, but the answer to that is short and sweet as yes.
Okay, great. I see Trevor is still young. Oh, still young. His surname is Young, but he's still on. So Trevor, maybe if you want to reach out to Stefan, you're more than welcome to do so, just to get an answer to your question as well. And then I think, Lindiwe has asked, can the trustee unreasonably reject the claim?
Yeah, no, that's also another topic in itself. Is that yes? Um, Technically, so it's not the trustee that rejects the claim; it's the master, or at least the magistrate, and that will decide whether a claim is proven or not. So trustees can um, oppose a claim. So, but it can happen that it's rejected, and then yeah, then you'll take further steps from there. I don't think I'm going to go into that now. Um,
Okay, great. So, Lindiwe, maybe also you can reach out to Stefan at our Claremont branch. And then to Mindri, if a rule nisi order is granted sine die, will the sequestration order then lapse?
So as I understand it, I don't think you can grant the rule nisi order sine
Yeah.
die. You can apply for it to be extended, but I think um, what you're trying to illustrate with your questions, you kind of have to have this line drawn in the sand. So I think maybe if I can answer it differently, if you've got a rule nisi on date X and the creditor hasn't taken steps to get a final order, that rule nisi can be discharged. I hope that yeah, but I think now there are
Great.
a lot of questions coming through, and I do
Yeah,
apologize. Yeah.
definitely. No, I think we'll take the last question before ending off. So that's from Shamareza. And
That's
the question
actually,
is
I
Section
know her
27
very
of the
well.
Insolvency Act and the anti-nuptial, and you're an
I will,
anti-nuptial
yeah,
contract.
but that's one thing I'll tell Sammy that I'll need to get back to her on that one.
Oh, okay. Okay,
I'll
cool.
just tell Sammy that I'll reach out to her directly about that.
Okay, great. Um, Sorry, is everyone fine if I just answer the rest of the question? If anyone needs to go, you can start leaving. But for how long can the debtor be under the cloud of having his company being liquidated and can trade again? So maybe rehabilitation, basically. I'm
So
assuming.
as I said earlier, rehabilitation, liquidation of a company is final. Um, you can't trade again, at least not through that company. Of course, you can set up a new company in specific circumstances. I'm not saying you must do that where you can start trading again, but obviously IP and those type of things still rest in the insolvent estate. But there's no rehabilitation of a company, but where it's with a natural person, the rule of thumb is 10 years, but there are certain circumstances where you can rehabilitate a lot sooner.
Okay, great. So I think that wraps it up for today. Thank you so much, everyone, and for your questions, and Stefan also for your expertise as always in terms of insolvency. As I mentioned, you're more than welcome to reach out to Stefan at our Claremont branch, and or his email address, Stefan h at stbb.co.za. I'll just post that in the group for everyone. And yes, thank you so much, Stefan, again for hosting this webinar and sharing your expertise with us.
Okay. Okay.
Thank you, everyone. Okay, bye.